Record the meeting as well. Okay, we're recording.
I think we're all set now. Okay. And we have all council present, right? Okay. Council, why don't you, well, before we get to the conference, to the scheduling conference, I want to review with the other members of the committee and get approval, hopefully, for the agenda for today's meeting. Judge Vanzi and Mr. White, have you gotten a copy of the agenda?
Yes.
Yes.
Somebody want to move its approval?
Yeah, I'll move its approval.
Second.
Okay, then the agenda is approved. We do not, the third item on the agenda is review and approval of minutes. Unfortunately, we do it from our last meeting. We do not have a copy of the minutes, so we can't approve them. But that's not a matter of life and death, and we'll just move on with the agenda. So the next item on the agenda is the item for which council for the mayor and the city council are present, and that is a scheduling conference. And I have a few questions, and then any other comments that the parties want to make or council for the parties want to make will certainly be interested in hearing them. First of all, my first question is, does either party or the council for either party expect to present evidence, whether through documents or through witnesses? Go ahead, counsel for the mayor's office, please.
Mr. Stelzner, nice to see you. It's Brian Nichols for the mayor's office. With me is Jennifer.
I have to comment, and please, folks, excuse my sarcasm now and then. I just can't help it. But I actually put on a tie today for the first time since I retired in February, and Brian doesn't show up with a tie. So please on the record. Go ahead, Brian. I'm sorry.
Perfectly fair, Your Honor, but you did trap me. I'm in Dayton, Ohio, and I couldn't find a tie quickly enough.
They don't have ties in Dayton, Ohio.
Exactly, but we can note that Mr. Miller and Mr. Woods have ties on, and Mr. Jackson. If those are all for the council, we're in big trouble at the mayor's office. So, but I'm glad to be here. With me is my colleague at Modrel, Jennifer Kittleston. I say at Modrel because I've accepted a job in-house at a company called Dene Development Corporation. It's located in Scottsdale, Dayton, and other locations. So, but I do still have an of council role at Modrel. So Jennifer Kittleston is
representing the petitioner, right, at the hearing.
Yes, that's correct.
Okay. Ms. Kittleston, welcome.
And also is Chief Jaramillo under where it says Albuquerque Fire and Rescue. And I believe that's our people present. We've conferred with Mr. Miller yesterday. The parties do not anticipate presenting evidence by document or testimony, subject to what you may want the parties to provide on May 1st as authorities. And we may provide 2 or 3 documents stipulated, such as the resolution.
Okay.
And good morning, everyone. This is Justin Miller on behalf of the Albuquerque City Council. Like Mr. Nichols noted, my colleague Michael Woods is with us today, and Kevin Morrow, counsel for the City Council, may be attending by phone, but I'm not sure if he's here or not.
Okay, welcome, Mr. Miller and Mr. Woods.
And Mr. Morrow's on the call. He's on Zoom.
Great. So that's the representation for the council. As Mr. Nichols said, we agree. We did confer yesterday about the questions that the committee had and agree that we will not need to present additional evidence. We thought we would attach or send our exhibits along with the authority to the committee so they're easy for you all to reference, but we don't plan on introducing additional evidence.
Okay. So the attachments to your submissions will be part of the record for the hearing. Is that right?
That's right. And I do have a question about that. If you're open for a question. We did cite to the recordings of some of the debate regarding the resolution and from a few years ago. We could either, if it's easier for the committee to view those on the link, that's fine, or we could submit an electronic snippet or a copy of those recordings, whichever you prefer.
Judge Vanzi and Mr. White, what are your thoughts on that?
I'm comfortable with just having the link.
I am as well.
Okay, then that's fine. We'll do it that way. Okay. So anything else from the parties on the question of whether evidence will be presented? Okay, sounds like we've covered it. Okay. The second item that I have for today are the dates of the hearing on the merits. And by the way, if I haven't mentioned this to the parties or their counsel, I have mentioned it to my colleagues on the committee. The committee would like to do the hearing, even though there's not going to be evidence presented, in person. And we will, both sides, I assume, would prefer that as well.
That's correct, Your Honor.
Okay, I see a thumbs up from Mr. Woods, and I see a thumbs up from Brian as well. So, okay, good.
Agree. Yeah.
The dates that we have circulated within the committee and with the personnel from the city who are assisting us for the hearing on the merits are, and correct me if I'm wrong, anybody, either Mr. White or Judge Vanzi or the folks who are here with me in the conference room, are either June 3rd of this year from 12:30 p.m. on, let's just say from 1 p.m. on in the afternoon, and June 4 of this year from noon. I have either starting at noon or at 2 p.m. We're assuming an approximately 2-hour hearing, and it sounds to me from what you all are planning to do at the hearing that should be enough. Tell me if it's not, but that's what our assumption is going in. So do those dates work, first of all, for counsel for the mayor?
They work for me personally, Your Honor, and we'll assume that AFR and Jennifer are okay with it unless they pipe up. And Mr. Miller and I did speak yesterday, and we were thinking up to 2 hours. So you're right on track.
Okay, good. Mr. Miller, what about those dates for you all?
Those dates are fine for us. And also regarding the 2-hour hearing, that's fine.
Okay, well, so let's just make the decision now. I'm just going to go ahead and decide, assuming everybody agrees, that we'll hold the hearing on June 3rd of this year, and we'll start at 1 p.m. Okay? All right. Just making a note here.
Sheriff Seltzer, would you, so I can reserve the council chambers? Or would you like me to look at other locations within the city?
Let me just take, I think I recall what the council, council, are you all familiar with the council chambers? Because that's what we've been talking about as a location for the hearing. Are you familiar with those chambers?
We can also do basement Plaza del Sol.
Yeah, is that a yes?
Yes, and that would be fine with us.
Any are fine, Your Honor, wherever you pick. Plaza del Sol is fine, City Hall is fine, doesn't matter.
I think what I'm gonna wanna do, just to refresh my memory, Cristobal, if we could just walk over there right now and take a look.
Yeah.
My recollection is it will work. Judge Vanzi, were you saying something?
No, I was just listening to what you were saying, and that's fine with me.
And Mr. White, that's okay with you? You're obviously
Yeah.
familiar with.
Either is fine with me. I think Plaza del Sol's a little less overwhelming for the number of people we've got, but I think either would work.
Have a conference room is big enough here?
We have a hearing room in the basement. We will research facility availability and update, and we'll send it out. We'll notice it in the notice.
Okay. And hopefully if all council continue to behave the way they are, which is very cooperatively, we'll give you the right location, not some other place where you could go in futility. All right.
Well, behind the scenes, Mr. Miller has been very difficult, so I would suggest sending him the wrong location, but certainly the mayor's office should receive the correct location.
Then it'll be a short hearing at least, that's right. Okay. And then we talked about the length. Council, and the parties, as far as they're represented here, agree that a couple hours is will probably work. And obviously, if we need a few more minutes, lawyers being lawyers, we could accommodate that. Okay, and again, we'll let you know in the notice the location of the hearing.
Great.
Okay, is there anything else that either Judge Vanzi or Mr. White think we should cover today in this scheduling conference?
Nope, I think that covers everything. Thank you. And thank you, everybody, for being here and for your written product as well. Appreciate it.
Don't go away yet. We have one other item after we finish the scheduling conference. Mr. White, you're okay with it? Everything we've covered so far?
Right, I think we're okay as we are right now. So we're going to have a list of authorities and evidence on May 1st. Is that what I'm understanding?
Yeah, I believe so, Mr. White. Yeah, we will. I think we're supposed to get you electronically the actual authorities by May 1st. If that's not correct, let me know. And then we will also, at least for the city, or at least for the mayor, really, I think the only things we think are material are the 2016, the 2025 resolution, and the document showing that the mayor did not veto or sign, which is factually correct. But we'll make sure I'll clean that up with Mr. Miller, and if he wants to present more, we probably won't object. We probably will just think they're not material to the decision.
And obviously, Mr. Miller, do you want to comment on that real quick? And then I'll get you.
That's fine. We were not planning on adding anything that was not submitted to the committee in the papers.
Okay, Mr. Watson.
And to the members of the committee, I apologize. So we had, at the chair's direction, I had sent a letter to the parties asking that they prepare a binder of the cited authorities and give it to us so that we can, either an electronic or a physical binder, that they give it to us so that we can get it to you, so that you have all the cited authorities by May 1. And so that's where the May 1 deadline was coming from. But I did not send that letter to the committee itself. So that we can anticipate the next week, unless the parties have any issues with that deadline. Our hope is that we can have a binder or an electronic or physical copy of the cited authorities so that the committee can be fully prepared for the merits hearing in June.
Okay.
It
That works for you, and Mr. White, does that work for you?
Yes, I think that works for me.
Okay. All right. And then
I would ask, sir, would you prefer like the entire charter or just the selected portions? What's better for the?
I think just the selected portions, but
Okay.
I think Mr. White has memorized the entire charter, so this one doesn't need it at all. So.
Well, we were going to put in his photo and see if that was good enough, but
Yeah, that might work. That's for sure.
So please spare us any photographs. All right. Anything else, council, that we need to discuss in the scheduling conference? The committee has one more item on the agenda that you don't need to be here for.
One thing to clarify, the letter yesterday had said an electronic copy of the authorities. Is that okay with the committee, or we could submit hard copies if that would be better, but we were planning on submitting an electronic copy.
Judge Vanzi?
Electronic is fine.
Electronic's fine with me as well.
Okay, fine. I will need somebody to produce it for me on paper because I'm a very old man, but electronic is fine.
Yeah, if the parties can just give it to us electronically, we can
They
print
can get
a
it to me.
physical binder for
Yeah.
Mr. Stelz.
Yes.
Great, thank you.
Okay, thank you very much, council. Judge Vanzi and Mr. White, stick around for one more item.
Thanks, everyone.
Thank you.
Okay,
And I should clarify, I was not anticipating that we were going into closed session for this. But I should defer to the chair. I was just thinking that Mr. Jackson could give us a short overview of the conduct of committee members in general for quasi-judicial proceedings. I don't think that's privileged, but to the extent we need to go into closed section, I don't actually think we properly noticed that under OMA to do a closed session.
I don't believe we need to.
Okay.
Judge Vanzi,
No.
Mr. White,
Nope.
I assume we're just gonna get a briefing from Mr. Jackson on our conduct in quasi-judicial proceedings. First of all, Mr. Jackson, do you approve of my dress?
Yes, yes, Chair.
Mr. Chairman, if I knew you were going to wear a tie, I would have put one on myself.
I should have given you notice.
He wanted
Right.
to stand out, which is why he did not give advance notice, and we have now all noticed, so we're all in good shape.
Go ahead, Mr. Jackson.
Thank you. So the question has arisen about conduct in quasi-judicial proceedings, specifically political activity outside of the committee. As I'm sure all of the committee is aware, there is a mayoral election this year. And really the question is to what extent can the committee members participate in that without creating problems for the work of the committee. There's not anything directly addressing that question on political activity in New Mexico law, and resort to federal law is, persuasive at best, because most of the cases that we have analyze the issue of bias in the context of a due process challenge to an administrative decision. But because the only parties to a proceeding before the committee are the mayor's office and the council, it's all the city. And as an arm of the state, the city doesn't have a due process right. But under New Mexico law, the same standard applies, right? The parties are entitled to a fair hearing. And even if they weren't, as a matter of good government, that would be the way to go. So in terms of the activity, obviously, if the members abstain from any activity during the election cycle, apart from their participation via vote, then no question will arise. That's the easiest and cleanest way to avoid any allegation of bias.
Sure.
But to the extent that members do wish to participate, it may give rise to challenge, and it's not entirely clear how that would come out. So just by way of background, and Member Vanzi will no doubt be familiar with this provision, but for judges, judges can attend, unless prohibited by law, non-fundraising political gatherings. That's about it. And that's in Rule 21401 of the Code of Judicial Conduct. Now, in Los Chavez Community Association versus Valencia County, Court of Appeals said that New Mexico law binds quasi-judicial decision makers to ethical standards comparable to those that govern a court in performing the same function. And that is that case involved something other than political activity. It involved a relationship between the commissioner, who was part of the tribunal, and one of the applicants before the board. They were cousins, and that would have been impermissible for a judge under the New Mexico Constitution, and it was thus impermissible for the commissioner. So that again, it's a different context, but there's a strong relationship there between the conduct that would be expected of a judge and which would be expected of a tribunal. The principal case on these issues is the Reed case. It was a licensure case involving an optometrist. And the standard that was set there is that at a minimum, a fair and impartial tribunal requires that the trier of fact be disinterested and free from any form of bias or predisposition regarding the outcome of the case. In addition, our system of justice requires that the appearance of complete fairness be present. And I think that's where we probably want to be concerned. The inquiry is not whether the board members are actually biased or prejudiced, but whether in the natural course of events, there's an indication of a possible temptation to an average man sitting as a judge to try the case with bias for and or against any issue presented to them. And that standard ultimately comes from, long-standing rules governing the conduct of first federal judges and then state judges. Although it is phrased as an objective, reasonable man standard, I would note that in federal cases, motions for recusal, the reasonable man or woman is really the reasonable lawyer or judge. It's not, there are recusals that are routinely denied when a layperson would think that a recusal would be appropriate. Now, in Las Cruces case back in '97, the Court of Appeals cited to a treatise that distinguished 5 kinds of bias, and those would be 1, a prejudgment or point of view about a question of law or policy, even if so tenaciously held as to suggest a closed mind, is not more without a disqualification. 2nd, similarly, a prejudgment about legislative facts that help answer a question of law or policy is not without more disqualification. 3rd, advanced knowledge of adjudicative facts that are an issue is not alone a disqualification for finding those facts, but a prior commitment might be. And then 4, a personal bias or personal prejudice, that is an attitude toward a person as distinguished from an attitude about an issue, is a disqualification when it is strong enough. Such partiality could be animosity or it could be favoritism. And then 5th, which is not really at issue here, is one who stands to gain or lose by a decision either way has an interest that may disqualify. Even a legislator might be disqualified on account of a conflict of interest. And that's the sort of conduct that's really reached more by the GCA, the Governmental Conduct Act. In that case, the issue was that the chair of a labor board who had been appointed on the recommendation of labor interests was alleged to have been biased by the city. And what the court said is that even if he had previously expressed support for aggressive unionization of the public sector, he would not be disqualified. Members of tribunals are entitled to hold views on policy, even strong views, and even views that are pertinent to the case before the tribunal. And then there's a follow-up case that also involves a body rather than just a hearing officer, because I think that's probably going to be more instructive here. And this was the State Corporation Commission on a rate-making case, recognizing that people are going to be appointed in part because of their views generally. And this is the In U.S. West case from our state Supreme Court in '99. And then it just restates that Reed standard. And then in Phelps Dodge, this was a case involving the Water Quality Commission. And there, the court talked about in selecting its public members, right? Because some of the members of that commission are gubernatorial appointees, and I think it probably has, well, I don't remember what the other constituent appointing bodies are, but there are 3 public members. And in selecting those public members, the governor will likely select those members from pools consisting of people who have been politically and publicly active, from industry, and those who have expressed their views and who have been engaged in the regulatory process. And it's unrealistic to expect that the public members will be people who have not taken positions or people who come with a clean slate. The commissioner whose bias was challenged there was an active member of the Sierra Club and had a certain philosophy on environmental issues. And that by itself is not enough to disqualify. So the general contour is that these tend to be, when there is a disqualification, it tends to be very driven to the issues that are before the tribunal specifically, and not sort of a general philosophy. There was a case fairly recently where a commissioner had published an op-ed on the issues that were before the tribunal. And
that was my case, by the way.
oh, was that? Yeah, because you were there was the Benavides, and the district court on appeal from the tribunal decision said that it was error for the county to not consider the motion to recuse. The court of appeals agreed with that and said that we can't find that it's an error under an administrative review standard. So, there's some deference to the district court there, but only on the question of whether to consider the motion to recuse. Because that commissioner was no longer on the board, the court of appeals didn't reach whether recusal or disqualification was appropriate. So again, the easy course is to stay away from the campaigns. That way you don't have to fight about it. And certainly you want to be careful about advocating on issues that come before that have come or are likely to come before the board, because those might give rise to allegations of bias. That said, a general point of view, particularly given the composition of this board, where one of the members is appointed by the mayor and one of the members is appointed by the council, and then those two members have appointed the chair, that structurally helps protect against these sort of allegations, and it helps ensure a fair tribunal. But the parties will squabble, and
Yeah.
Part of this is and just this is not case is that personally I would always love to be able to beg off of an invitation by saying, sorry, I can't, I'm conflicted. But that just goes to my personal preferences for social activity. Do the committee have any questions?
Mr. Chairman, if I
Go ahead.
I had raised this, I think because I had been invited not by the candidates themselves, but by friends of mine who are politically active to these petition gathering and qualifying contribution parties, where you go to sign the petition for and quite frankly, one for the mayor and one for councilors as well. And I was reluctant to say yes, because I felt that might be something that might reach the level of bias. When I was after I retired from the city and was counsel for the county Code of Conduct Review Board, which was their board of ethics, the agreement I had with the county attorney is that I wouldn't become involved in political issues of any kind, just to avoid. I wasn't a member of the board, I was just the attorney for the board, and the idea was not to get involved in those political issues. So I just wanted to raise that, and one of the reasons I wanted to raise it before the board was in the Benavides case. They said, the board should really kind of have a discussion about what they think might be bias and what might not be bias. So I thought it would be appropriate in this case for us at least to have a discussion about it.
Chairman.
Lindsay?
Yeah, thank you. So I agree. I think it's important to have a discussion, and I think it's important to make full disclosures. Mr. Jackson, thank you for that presentation. It's one of the reasons I loved being a judge was so I couldn't do anything. I too am averse to a lot, which is, I shouldn't say that because I counted on people to be political on my behalf. My part is easy. I have not been involved in any of the elections or campaign efforts or anything with any city councilor or mayor candidate, nor do I intend to be. So my abstention is complete on that. And I don't need to raise anything. But I think that to the extent that there may be anything questionable out there, we should at least appropriately disclose to the parties.
Right, and I think I'm gonna just voluntarily just take that position that Judge Vanzi has, you know, I don't, you know, I can, I think that's the appropriate thing to do in this case.
Mr. Jackson, thank you for the presentation. It's very helpful. I just want to note, since we're on the subject, my wife and I have both received solicitations from the mayor's campaign, which isn't surprising. I don't think we've received any from any of the city councilors, but I'm just ignoring them. We are both going to ignore them until this matter is over. I'm not going to write them back and say, don't solicit. I'm just going to toss them in the wastebasket for now, until this matter is completely concluded.
Right.
Yeah, as I said, that is the cleanest course of action for the committee's business, and you know, to the
I'm sorry, Mr. Jackson, I couldn't hear that.
I said
Say
that is
again?
that is the cleanest course of action for as it pertains to the committee's business, and to the extent that the members want to look to the Code of Judicial Conduct, either soliciting funds for or paying a contribution to a political organization or candidate, those are off the table. But again, that's that rule doesn't expressly bind the committee, but I would advise following it just to avoid the hassle. And then one other note that if there is an allegation of bias at any point, the committee is charged with determining the allocation of powers between the office of the mayor and the city council, not this mayor and this city council. So that there's a as I'm sure the committee members are well aware, that they're going to be writing for future administrations as well.
Anything else from anybody on this matter? Okay, then I believe unless Judge Vanzi or Mr. White have any other items to discuss for this agenda.
Sorry, did we,
Yes, go ahead.
did we actually take a vote on approval of the agenda?
Yeah.
We did. Okay.
Yes.
All right. Okay.
Yeah, there was no vote on minutes because there were no minutes.
Right.
Yeah.
Okay.
Yeah.
So we're good.
Okay. So do I have a motion to adjourn?
So moved.
Second.
Okay, we are adjourned. Thank
Thank
you
you
all.
all.
And we'll be letting you know the location of the hearing, and we have the date and time, so I think we're all set.
Thank you.
Okay,
Have a
thank
good
you.
weekend, everyone.
Oh, and
Okay.
Ethan, before you disconnect, could you send me a copy of that letter as well? With
Yes.
the first deadline, and for me, electronic is fine for the materials that are submitted by the parties.
Okay. Sounds good. Thank you.
Thanks, everybody.
Cool. Thank you.
Thanks. Appreciate you.